Hello, everyone. I am Anthony Mills with Global Innovation Institute, and I would like to welcome you to our webinar today. Global Innovation Institute is the world's leading membership and certification and accreditation organization in the field of business innovation. And we host a regular webinar series dealing with different topics on innovation. Today, we're hosting Mr. Anant Kataria, who will be talking to us about driving innovation through intellectual property. So I'm going to introduce Anant to you, and after I introduce Anant, then I will turn the floor over to him. So Anant Kataria is the CEO and co-founder of Sagacious IP, an IP services firm providing solutions to companies, law firms, and other players in the IP ecosystem throughout the IP lifecycle. Sagacious boasts an outstanding team of brilliant people committed to their client success. The firm helps senior leaders in R&D and IP, patent agents and attorneys practicing IP law, private equity firms investing in tech companies, and people involved in patent acquisition or monetization, as well as people responsible for IP and research institutes and other people whose work involves IP. They help all of them to achieve their objectives faster, cheaper, and with more certainty through customized solutions, products, and services. Indeed, Sagacious IP has helped its clients save over $500 million and make over $1 billion by allowing them to address key challenges they face in different aspects of the IP lifecycle. The firm's intention is to make the possibility of such an impact available to as many clients as possible. So Anant and his co-founder, Tarun Kumar Bansal, co-founded Sagacious back in 2008. Since 2008, the firm has served over 2,000 customers with quality IP solutions. Its clients' trust and repeat business have helped it to grow to a team of over 300 professionals today, which is amongst the largest in the IP solutions industry. In 2014, Anant and Tarun were selected as Young Turks, a highly regarded award in India for young entrepreneurs, and were featured on a CNBC TV show by that same name. In 2015, Sagacious was awarded the Red Herring Asia 100 Award. In 2018, Sagacious was certified as a great place to work. And then this year in 2021, Anant was named in the Times 40 Under 40 list in India. To further Sagacious' objectives in North America, in 2019, Anant moved to Toronto, Canada, where he's been focused on actively driving the firm's North American customer engagements while continuing to grow Sagacious IP otherwise. So please join me in welcoming Anant Kataria. Anant, the floor is yours.
Wonderful. Thank you, Anthony, for such a nice introduction. I have really loved the way you introduced Sagacious. Thank you so much. So, I'll jump on to the topic for this webinar. So the intention is to talk about leveraging IP to drive innovation. And I'll touch upon points that talk about driving innovation and also about why one should consider IP in an organization or in a small company or even as an individual inventor, as it brings in a possibility of generating revenue. And I'll talk about various channels that are available to us in that regards. So the agenda today is going to be how to use IP to trigger innovation, and then how to leverage IP as a barrier to competition. And I'll give some examples in each of these cases. Then we'll talk about monetizing IP as a direct revenue source. And then we'll talk about some of the advantages that Sagacious has or offers that Sagacious has for Genie members. So using IP to trigger innovation. And also, just before I start, I would like to state that in the chat window, while I'm talking about any points, if you have any questions, please feel free to write your question in the chat window. If it's possible to take that question while I'm presenting, I'll take that up at that time. Otherwise, at the end of the presentation, I'll take all those questions, and Anthony and I will try to answer those questions together. So first thing I would like to touch upon is how IP helps a company, small or big, understand what needs to be innovated. Usually, from my experience of working at companies like Suzuki Motors and then serving many companies in the IP space, what we've realized is that at times the internal people in R&D teams, whether it's a big R&D team or a small R&D team, or if it's a startup, then everyone is essentially a member of the R&D team. So what they're working on uh, is highly focused, and at a lot times it's like very limited to uh, the way they've been used to thinking and working. That's where uh, understanding what others are doing, not just from what you see in the market, but also from what they've patented or what they've filed patents for, and then identifying what is still left, where there's a room for you to innovate and still lead the market, how that helps in driving innovation. So this is called white space analysis, where we try to identify what are the white spaces in your product area, in your market or industry, where there's still a room for you to go out and innovate. So, generally, how this can be done is you quickly collate uh, IP related to a product or technology. Then you analyze and categorize all that IP. And when you categorize out all that IP, you try to, when I say IP, I'm talking about patents. So in any industry you pick, whether it's pharma, whether it's the telecom industry, household appliances, any industry, any product you see, you get your hands on, there are going to be at least some patents around that product, which have been filed by people all across the world. Now, when we, let's say, just imagine your industry, the products that you're working on, and let's say if you want to identify in that product segment where you can innovate and still lead the market, even when all these big companies exist, and probably you in a way compete with them for the market share. So what you can do is get all IP related to a product or a sub part of that product or a technology related to that product. Then you analyze and categorize those patents. So when you are analyzing them or categorizing them, you identify what are the problems each of these patents are solving. Then you try to identify that, okay, problem A is being solved, and how are people trying to solve that problem? What is the inventive part? Where are they bringing the innovation to solve that problem? Then you identify what are the features that they're talking about in the patent. So let's say they are talking about a specific problem, and let's say they are changing part A of the product to solve that problem, and these are the features that it brings when they solve the problem by changing the part A. I'll talk about another example as we move forward, and that will make things clearer. Then you also track what are the application areas. So probably at times uh, invention is related to your product. Hypothetically, let's say it's related to a mobile phone camera cover, for example. But the way the patent has been written, they're also talking about other application areas apart from mobile phone camera covers. Maybe let's say they're talking about uh, adventure camera covers, or let's say covering sensitive parts of other products which are not essentially cameras. So you kind of also get an idea of what other people are uh, what other application people are taking similar inventions into. So you might be, when you go through such an analysis, you'll be able to identify such additional opportunities. Then you locate the gaps. So this is what people are already doing, and you still see there's a gap in certain categories. You'll see there are no patents there or very less patents there. That gives you an idea, okay, this is an area where not many people are thinking of, or at least big companies or your competitors are not building patent portfolios by solving problem solving a particular problem or solving that problem in a particular manner. You can focus on that, and if you're able to come up with something new there, you will have the opportunity of leading that particular problem solution area. So just to give you an example, let's say we're talking about uh, drive by wire technology. So uh, traditional driving mechanisms will have a mechanical linkage for your driving and steering, and then it with new cars it's changed to electrical system primarily, where the signals to your steering mechanism goes through electrical wires instead of mechanical linkages. So let's say if one were to do a white space analysis in this area, and you're analyzing all the patents, and once the patents are analyzed, you end up identifying that, okay, these are some of the problems that people are talking to solve. Let's say they're talking about inaccurate signal, so they're solving that problem. Slow signal, that problem. The wires that are going to give that signal, the wires are breaking, so that's a problem that people are solving. And these are the number of patents that you've identified, that talk about this particular problem. So wire breaking, 50 patents talk about solving that problem, 100 patents talk about solving inaccurate signal problem. And then as you move, in further analysis, you find that, okay, for this solving this problem, these are the ways in which people are trying to solve this problem. They're either concealing the wires, so to to prevent wire breaking, they're either concealing the wires, or they are changing the material of the wire, or they are mounting the wires inside car body instead of mounting them under the car body. So these are just hypothetical examples, but let's say when you come up with such an analysis, you see that there are not many patents here. So at least to start with, it gives you that this is a space where no one is trying to solve a problem of wire breaking by mounting the wire inside the car body. There might be some challenges associated with it, or it might just be such that people have missed looking at this way of solving the problem. Now, this gives you an opportunity. If you are alone or working in a team, or if you're in an organization and uh, you work on these products, this gives you an idea as to, okay, let's pick this up, let's have a brainstorming session, and let's see why is this area neglected. And if it's neglected because no one focused on that while they were focusing on other ways of solving this problem, and you see an opportunity, you see that this is a viable solution, you work on that, you start filing patents there. And if it turns out to be a working solution, you will be leading the IP space there in times to come. And that gives you an opportunity to make money with that IP that you have. Or if it's not about making money out of your IP, you end up bringing out products in the market which are unique. Now, second is inspiration to build and innovate further. Again, existing IP can also help you identify opportunities to build and innovate further. So, for example, when you are in US and you look at all the foreign IP related to the product or the technology, let's say mobile phones, mobile phone cameras, for example, and that's the market that you operate in, you want to identify what are the innovations that you can you know start working on top of without potentially infringing on anything. So you get a base to already start innovating upon. So you kind of identify all the foreign IP related to mobile phone cameras that's not protected in US, and then you again analyze and shortlist. By reviewing them, you like certain technologies which are not protected in US, and you would like to work further on those. And then you brainstorm, innovate, and build upon those. So if you want to drive innovation, this could be a good seed to drive innovation on. For example, uh, in the years 2015 to 2019, there were around these many smartphone camera patents that were filed, and they have no US member. So basically, hypothetically, let's say most of these patents were filed in, let's say, China, Europe, India, wherever, but they don't have a corresponding or family member filed in US. So these patents are free to use in US. So then you analyze them and shortlist them, and let's say you find a patent which talks about detachable camera module that can be used as a front camera and can also be used as a rear camera. And you like this patent. Now, because this patent is not valid in the US, uh, by you almost or potentially you are in a situation where you can just use it to pick that pattern, understand how it talks about implementing the invention, start implementing in your products as it is, or innovate further on that and then start implementing it in your product and launch it in the market. Now, this is possible if there are no subsequent or prior patents which limit the use of any other supporting technology which is required. But let's say hypothetically you find a patent and this is a standalone patent that can be implemented. It is not granted in the US, not filed in the US, but is filed elsewhere and granted elsewhere. You are free to use it. Then so you take this two-way camera pattern, you brainstorm and innovate, and build upon it, and you include it in your product. So this is another way for you to get inspiration of new ideas and build them in your product or innovate further on those. Now we talked about foreign IP. Now there's another way to identify free to use IP, which is patents filed in US itself, but the ones that have expired. So what you can do is, let's say you pick up all foreign IP like we did earlier. Also pick up all expired US patents or lapsed US patents. Expired are the ones that have been through, their life is over. So the life of 20 years from filing, that is over. And lapsed are the ones whose 20 years are not over yet, but the patent owner has stopped paying maintenance fee and it is free to use now. Since they're not paying maintenance fee, even though the life is pending, they don't have any rights to exercise that patent. And then now it's free in the market. You can pick it up and use it. Then you again analyze and select the patents that you think are good for you, uh, and you can straight away implement them in your product. For example, again taking the period of 2015 to 2019, so there are 126 out of 2900 patents we found in that space. 126 patents have dead US members, so either so they're essentially lapsed. So you analyze and select the patents. So like in this case, we, just as an example, we picked up a patent of a removable lens assembly like this, including a lens holder. So you see this lens assembly that this person is wearing. So it has a lens holder and it also has a lens coupled to the lens holder and a coupling interface. So these are technicalities, but look at it. It's something that helps you. That's an attachment to enhance your camera lens, and it's a wearable attachment. Now you identify that patent. It probably has a US member, but it's expired, and at the same time, or it's lapsed, so it's free to use. And then at the same time, when you look at that patent, you see that this patent has been cited by GoPro. This patent has been cited by Pogotech. So that gives you an idea that okay, companies like GoPro and Pogotech are building on top of this invention. So that when you're looking at these patents, you look at various factors. This could be one factor, that who's citing it, who's probably building further on top of this invention. That gives you an idea as to okay, this is probably a good invention. Uh, I should implement in my product. And then you take that and you implement it in your product. So this is an example of picking a free to use IP, adding it in your product, and then enhancing your product and launching it, or launching a new version of the product in the market. Now I'm taking examples of phone cameras here, or these areas. It's primarily because I thought it was more relatable. You see that and you're able to picture uh, how this whole process works. But the same thing can be applicable any area, any industry that you're working on, any product that you're working on. Um, and it's more, I would say, it's quicker and faster, more effective in areas which are further niche, which are not like so so public, because the number of patents are less, so you don't have to spend a ton of time in bringing those, uh, identifying those patents that you can use.
Hey, Anant, can I interject a quick question?
Yes.
So if I find a patent in another country, but it's not in the US and I want to use it in the US, do I need to try to patent in the US, or I can't do that because there's prior art? How does that work?
Yeah, that's a good question. So, you can patent on. So to get a patent, you need something which is globally novel, which has never been done in the world before.
I
So
see.
you'll not be able to patent something that you pick from elsewhere, but you'll be free to include it in your products without infringing on anyone's rights.
Okay. Thank you.
So moving further, I'll talk about leveraging IP as a barrier to competition. Uh, so patent is a negative right. Negative rights are the ones where by having a patent, you don't get the right to practice it. You don't get the right to implement it and launch products that have the technology that's in the patent. But you have the right to stop others from using that patent. Now, the reason you don't get the rights to implement your invention in your patent is because, let's say, my invention is related to enhancement of the camera of a phone. So maybe I am able to make sure that the images are sharper when I take my invention does that. And if I want to launch a phone that has this feature, the moment I launch this phone out in the market, apart from that enhanced camera, there are tons of other things that go out in the market: the phone, the inherent technology that makes the phone work, the telecommunication technology, the screen, the touch screen features, and all those things. I don't have patents on those, other people do. So take this example and put it on any product. Your innovation or your patent is about enhancing a particular feature. So you own that features, or that technology, or that enhancement, but the rest of the aspects or any other thing about that product is owned by someone else. So you cannot build the entire product and launch it without infringing on their rights. But if someone wants to bring that enhancement in their products, you have the right to stop them. So uh, a patent will provide you as a patent owner the right to exclude others from making, using, selling, or offering to sell, or importing the invention that you patented. And just to give, so this example has a PNG as the patent owner. And I again wanted to take an example that's relatable. Uh, but you could be an individual inventor with just one patent, and you still have the same rights, and people have exercised those rights in the past. So PNG was granted patent for their Mac 3
Coba
region.
pelan
Is Did someone have a question? Okay.
Continue.
Okay. And then Edgewell, they launched a product, this product, Schick PL, which was essentially, which infringed on the patent. Essentially, it had the same features, same elements that were claimed by PNG in their patent. Then PNG filed a case against Edgewell for infringing, and then finally there was a settlement in the favor of Procter and Gamble. So this is a very simple, the main concept behind owning patent and patenting your innovation, and this works. Similarly, so that was about utility patent, where what you've invented is something that works, something that has a utility. It could be a process, it could be a product, it could be anything with moving parts or interacting parts, and you have invented the functional aspect of those things. So any functional aspect, not just how they look, right? So that's what a utility patent is. Then the other thing is a design patent. So there are people who are good at innovating or good at bringing out new designs of things, where it's probably the same product, but with these modifications it's more appealing, people like it more, so probably that might lead to increased sales of the product, because when people go out in the shops, they see two products both having the same functionality, but one looking a certain way and the other looking a different way. So if your design, the appearance is more appealing, they might go towards that product, right? So those kind of inventions, those kind of creations of mind which have to do with the way things appear, they can be protected by design patents. Then if you have a design patent, it again provides and a patent owner the right to exclude others from making, using, selling, or importing a patented design or the ornamental aspects of the object. The object can have a practical utility, but the design does not give that object that utility. It only gives, it only enhances the appearance. A very common example or case study is how Apple leveraged their design patents against Samsung. So one beautiful advantage of design patents is that when you go to a judge, when you're, I mean, when your case goes to a stage where there's someone who's evaluating whether there's infringement or not, design is all it has to do with appearance. So it's very easy to spot infringement. This is what your design application looks like. This is what the product looks like. To anyone who can see these two things, they'll see similarities, and that's where the infringement can be easily ascertained, right? So even though it doesn't take a lot of time, a lot of technical understanding to come up with design patents, the protection that you get or the rights that you get are equally strong and well implemented. So for example, Apple, when they came up with iPhone, they filed a design patent which covered, let's say, if you look at this, you see the dashed areas. So they're not covering those. All they're trying to cover is a device that has this kind of boundary. And when you look at it from the side, there is again this is how it looks. And this base part, now this was the actual design of the original, the first generation iPhone, but again they've cleverly created it as a dotted line and not claimed it as a part of their design. Because the more you claim in your design, for you to find something that infringes, they would have to have all those things. So you try to claim as broad, as less limiting design as you can, or same applies to utility patent. But that's what Apple did here. And then Samsung came up with this product, this phone, which has very similar external boundary. The back design is not the same, but because Apple was very clever and not claiming that in this patent, uh, the way the bezel looks from the side is very similar to how it's in Apple's design patent. So essentially, Apple filed a case against Samsung. So this is just one patent. There were many other patents that were involved in these lawsuits. But the key thing is that majority of what Apple did against Samsung, a significant part was uh, by leveraging their design patents as against their utility patents, and they got a favorable judgment in their favor. Okay, so Anthony, if you've received any questions so far, or you want me to address something, or should I continue going forward to the next steps? I think you're on mute.
Yes, thank you. So there is a quick question in the chat window here you can take on real quick, and then you can carry on. But the question is, is there something called an open patent, like open source? That's a new one for me.
Okay. Uh, Open patent as such, there's no open patent. Um, there are various patent pools. What they've done is that, so let's say there are companies who are very committed to a certain cause. So they might, to promote other people to start working in that direction, they might make their patents available for free. So if you want to work in that direction, you can use this company's technology and you don't have to pay a penny as a license. So that thing happens, but that's all, dependent on what the patent owner wants to do.
In
So
fact,
like they,
a
yeah,
few years ago, Tesla did exactly that.
yeah, yes, you're right, yes. And that's very similarly, Microsoft, Facebook, and other company, they pulled in their patents very recently. I think on the Earth Day, this year, they pulled in their patents related to green technology, and they are giving that out for free as well.
So it becomes like open source code in effect, right?
Yeah, you go through the patents, you like those technologies, you start implementing them.
Is there an official legal filing they do to say people have the right to use this, or do they just put out a message? How does someone know they're safe in using it?
Mostly what they do is they'll do a press release that makes the general public know that this is available, and then they will put all those patents specifically on a specific portal. Like each of them have a specific website for such patents. You go there, you'll still have to sign a license agreement there.
I see.
Yeah, you'll go through it, you'll see what your rights are, what your limitations are, and then yeah, so it's not that you have to do a lot of effort spotting such patterns, but they have kind of defined the process for you. You follow that process and you'll be able to do it.
That makes sense. Having to sign a license agreement still kind of that addresses all the any questions, so there's no legal concerns or questions later on. There was one other question in the chat window you can take, and then we'll move on. So that question was, for the white space analysis, when analyzing problems, should we only check the granted patents, I guess, as opposed to the patents that are pending,
So with white space, our intention is to understand what people are doing, and the more we are able to spot what people are doing recently, the better it is for us, because we want to understand gaps that exist now. So going through just granted patents will not give you a good picture. Patents take 3-4 years to get granted. So if you look at just granted patents, you'll see the white space that existed 3 years back, but that's not what you want. You want the white space that exists now. So you go through all patents as well as pending applications.
Very good. That's a great answer. All right, so let's move forward then.
Okay, perfect. So now I'll be talking about how to monetize IP as a direct revenue generation source. So there are broadly, there are four ways to monetize IP. You sell your patents, or you license the technology, which is beyond just licensing the patents, or you license your patent through litigation, or you license your patent by joining patent pools. I'll talk about each of them one by one. So when I talk about selling patents, I'll talk about some statistics that will give us an idea of what could a patent be worth and what has happened in the recent past. So how it works: as a patent owner, you either go directly to the buyer and you sell your patent there. So buyers could be operating companies, Google, Etsy, just two random examples. It could be any company that you see might have use of your patent. Uh, or you go to defensive aggregators. So defensive aggregators are companies that pool in patents on behalf of their members. So for example, RPX is a company that has thousands of patents, and its members are companies like Google, Microsoft. Several tech companies are members of RPX. What RPX does is it buys several patents, pools them together, and then all its members are now they can use these technologies risk free, because RPX makes sure that by taking those patents out of the market, it is not allowing others to sue its members for use of those patents. It, so it's essentially, uh, I'm buying all the ammunition that is out there in the market so that my people don't get shot at. So that's what RPX is doing. And you have those ammunitions, you sell your ammunition to RPX. So these are just two examples. There are other defense aggregators as well. Then similarly, or you can go to NPEs. Now, NPEs are non-practicing entities. Uh, they do not build, manufacture any products and sell them in the market. They monetize IP. They will buy patents from inventors or partner with them, and then they will identify who infringes on those patents. They will probably sue them, or go out to them and ask them to take a license of those patents, and then they'll make money in that way. And the inventor also makes money in that way. And these NPEs would either want to just buy your patent, give you a lump sum money, and then take on the next steps on their own, or they're also mostly open to working in partnership. So they won't give you anything upfront or a part of the fee upfront, and then they'll take your patents, try to make money by identifying who infringes, and getting licensing royalties from them, and then sharing those with you. So you have the opportunity to go to any three of them, uh, or brokers, which is probably the next thing. Yeah, you can go to broker. So this time you're not directly going to the buyer, you're going to someone who's going to help you sell your patent. And these are some of the brokers. Ocean Tomo, we were talking about in the beginning. They Many brokers, what they do is you'll be retaining them, and they'll be going out, and they'll have some terms and agreements with you. They'll take a certain fee, certain percentage of the sales price, and but they'll do a good job in representing you, identifying buyers. They know people in almost all the companies that, if you go to a right broker that deals in those technology areas where your patents are, they will know companies in that area. They'll know the key decision makers, and they'll help you sell your patent if it's of interest to the buyers. Third is you go to a transaction platform, and now here you are yourself responsible for uploading your patents, reading what these platforms tell about, what their terms are, upload your patent, provide the information that is needed, and then wait for people to identify your patents on those platforms and contact you if they want to buy your IP. So there are some of these platforms are IEM Market, Patent Auction, Idea Buyers. There are many others, but these are just some examples.
Can I interject a quick question?
Yes.
I think it has to do with non-practicing entities, if you want to go back to that. But we've had a problem in the U.S. over years with what are called patent trolls, which are firms that just buy the IP just so they can sue other people and make money. and sometimes, the people who are supposedly infringing say, hey, there was prior art, but yet they got the patent, and it's just not fair. Any comment on that?
True, that's true. So when I say NPEs, I'm talking about similar entities, which are termed as patent trolls as well. What we've realized working in this IP space is that uh, there are companies who are essentially more who acquire patents without a lot of diligence, and uh, try to try their luck by going against multiple companies and trying to get smaller royalties from them, just to stop going after them. Whereas at the same time, there are companies which don't do that, whose job is to essentially help inventors, and they do make money in the process. But what they do is, when they onboard a patent portfolio or onboard a patent into their process, they do thorough due diligence. They, in terms of, like you said, validity of the patent, that they will not take a patent that is not valid. They will not take a patent that is not infringed. And once they are very certain that, yeah, this is something that this company is actually infringing on, and we are uh, truly helping an inventor in getting their due. That's when they take those cases on. So I think there are both kinds of players, and NPEs do include patent trolls. One has to be careful and use some references when they finalize a partner to work with.
Very good. All right, let's move ahead.
Perfect. So these are just some statistics from recent years. There's a company called Richardson Oliver's Insight. So they every year they do this survey of the brokered patents in the US, and they provide details about uh, you know what were the numbers, or what was the average price, what was the average size, who was the seller, who was the buyer, and all those kind of things. So I have picked up some good insights from there which might be helpful, and I'd like to show those to you. So in the year 2018-19, around $300 million worth of patent transaction happened through brokerage. So the ones that happened without brokerage, they're not captured in this analysis. Average price for a US issued patent uh, came out to be $280,000. Uh, and if you see in terms of who the sellers were, you would see that if we talk about just inventors, so we're not talking about NPEs, we're not talking about defensive aggregators or big operating companies, but if we just look at inventors alone, so when I say inventor, it's probably, let's say, the inventor himself or herself owns the patent, or it's a small company and the inventor is the owner of the company, and there are not many parties involved. So you would see that almost 15% of the patents that were transacted were inventor owned patents. So that gives us an idea that, okay, it is as an individual who's inventing and making genuine inventions, uh, we still have a good opportunity in the market. Then this is the average, this is the the asking prices data. So you would see that the median price for a patent asset, a US patent, was $227,000. Generally, all the brokered patents, the average was 143, minimum was 14,000, and minimum US was $29,000. And in terms of the domains, technology areas in which these patents were transacted, you would see that the most common fields, or one that we think of that most transactions happen, they are definitely there. Software is there, hardware, communications, and then there are other spaces as well. So you'll see that, okay, software has a huge amount of highest number of, I would say, transactions, but at the same time there are hardware related patents which were transacted, and there are other fields which, let's say, household inventions and stuff, that were also there in the transacted patents. And in terms of distribution of package size, you'll see that more than 50% of the packages that were sold had less than 5 patents. So you don't necessarily have to have a huge portfolio of patents uh, to be able to succeed in generating money by selling your patents. Even if you have 1 patent or 2 or 3, up to 5 patents, 50% of the transactions were done for such entities. This is an example, a Israeli company called Vocal Tech. When they were running into losses, they sold their patents and generated $15 million out of those. And then they were able to get up and running. So the key point here is that if you're in a business, it's always a good, uh, it's always a recommended approach to keep protecting whatever you're building, whether it's the way it looks, the way your product looks, or the way it works. uh, you never know that the IP that you generate, which doesn't cost a ton when you're generating it, might act as assets that you can later mortgage or sell to get funds to keep your business intact. And this applies to these small companies that have done that, and it also applies to the multi-billion-dollar companies like BlackBerry and Nokia, who and Motorola, who were essentially you know whose IP sailed them, helped them at various stages of the business. Then the second app aspect after sales is technology licensing. So in technology licensing, you're essentially transferring your IP, but at the same time, you are transferring your design specifications, your product knowledge, and you're essentially helping the other guy who's taking your technology license to implement that technology. So you'll see you as a licensor will give the IP rights and design and product specifications to the licensee. uh, I'm going a little fast now because I know I have less time left and more slides. So uh, this is an example of Aero Farms. Aero Farms is an American indoor farming company in New Jersey. So what they uh, did was, they thought that leading weight would address food crisis was to use their indoor farming technology. So they went out licensing their technology to whoever wanted to use it. Uh, Again, it was not like a free license; it was a paid license, and then they were able to successfully do that. So if you're building something which is good there, and instead of just licensing your patents or selling your patents to people, you provide that uh, provide them the right to use your technology by actually helping them use your technology. That works, and that's a good way of growing a genuine business. So that was an example. Aero Farms was one small example, and there are these companies that do a ton of technology licensing, and there are many more. But I just wanted to share some examples here. And the third way of making money through patent licensing is through litigation. Now, patent litigation is the legal process when someone who owns the patents for a particular invention enforces their rights by suing another for manufacturing or selling or using their invention without permission. And again, I already talked about NPE, where NPE can help inventors in making money, through their IP, and in many cases that requires a lawsuit, and then they are able to take care of that lawsuit. So you, as an inventor, as a patent owner, uh, do not have to worry about that. They are your partners. They will definitely take a share of the money that is made, but they'll handle everything. uh, so this is an example of an inventor, Barbara Laskin, who had a patent related to bicycle pet carrier. And the inventor tried to monetize this patent themselves. They were not able to. Then they went on to this NP. Now, uh, I'm using this example and this NPE. There's no relationship between Sagacious and this NPE, and I'm not promoting them. It's just that we wanted to bring out case studies here for this presentation, and this case study was an easy to find, relatable case study. So I picked that and I'm sharing it here. So, the inventor contacted this NPE. They were able to file lawsuit against Pet Gear and Pet Ego, and eventually they were able to uh, once they filed a lawsuit, they were able to get on settlement table and discuss, and they were able to generate revenue for Miss Laskin. uh, other is Other way of monetizing your patent is by joining patent pools. So as we discussed, a patent pool is when two or more companies who want to pool in patents about a particular technology. So I give my 10 patents, the other company gives their 10 patents, and together now essentially we know that over these 20 patents cover the entire spectrum of this technology. And if someone has to use this technology, they just need to take a license of our patents, and then the majority, and they'll be free to actually implement this technology because this set of patents covers the majority of protected IP, protected inventions out there related to this technology. So these kind of patent pools can be formed. If you are innovating in a particular area, you uh, can try to identify if there are patent pools in that area. You will find if there are, and then you can just reach out to them. They might be happy to onboard you as a member of the patent pool. Every patent pool has their own criteria to onboard members, but they also have very clear a way of getting the licensing revenue to you. So now they have a team set up or an infrastructure setup where they are reaching out to uh, people who are using the technology in the patent pool, and that's an activity they are doing. You don't have to get involved in that as long as you have a patent that can go into the pool. Then they'll be generating revenue for you. You'll keep getting the revenue that due to you. So this is just a pictorial representation of what a patent pool is. An example. So there are many patent pools. Avanci had a 4G patent pool. Mpegla. This is the MPG patent pool. There are all these, and there are many more. They are all, each of these pools associates to a particular technology. Uh, then yes, like I mentioned, HPE, Facebook, and Microsoft, they've pooled in to create a patent pool, which is with that grants free access to their patents related to green tech or low carbon tech.
So now we have a number of questions we want to get to, so we probably want to try to zip through the rest of it and let's address some of the questions.
Sure, it's all done. So now, so this is the uh, benefits that Sagacious would like to offer to members of JNE. So we have a virtual IP officers platform, a virtual IP office platform. So through that, we will give free login access to all the members of JNE. So you can log into that. Uh, there you will be able to raise your queries through the platform. And those are we'll answer those queries for free, no charges for that. If you'll getting answers from IP professionals at Sagacious, whether it's related to IP law or it's general query as to, okay, this is the situation I'm in, what are the opportunities that I have, what can I do. So all the questions that you might have right now or you might have later, you feel free to go to that platform, submit your query, and we'll come back to you. And then if you end up requiring any of our services, we'll be happy to offer a 5% discount to all members of Chini. And the third thing is the knowledge hub and other products that we'll keep adding to our virtual IP office. So you'll have access to that. Our knowledge hub has several videos, webinars, documents, articles about IP, innovation, how to use your patent, how to monetize your patent, how to write a patent application. So many aspects in the IP space are there in single repository. So you'll be able to get a ton of information there. So this is what the portal looks like. This is how you can submit your query. You just select the industry, query type, and you write your question. You can even book an appointment to talk about your query. And this is a snapshot of what kind of content you can anticipate to have here. So there are basics of IP, introduction to invention disclosure form. So there's essentially content right from when you're conceptualizing something right up to when you're monetizing it. There's content for everything, so you'll be able to get access to that. With this, I am through with my part of the presentation.
Thank you, Anant. And we would encourage all of GenI's members to take advantage of this benefit and use the Sagacious platform and as a great resource in your innovation work. So let's turn our attention to a few of the questions we have here briefly and see if we can answer some of these very briefly. So the first one, can you specify the specific rights during the selling process to be used only by the first buyer? I mean, you can customize that however you want, right?
Sorry, could you go with that question?
When you're selling the IP or you're licensing it, can you tailor the rights and be very specific about what the rights are?
When licensing, yes. When selling, then you are actually foregoing your rights. So then the other person who gets the patent, they will have all the rights, but there could be certain conditions. For example, you can have a license back. So even when they have the patent, they will you still get the license to use it if you want.
Mm-hmm.
And there could be certain other cases, like for example, many times when people want to sell patents, they also want that the buyer will not further sell it to an NPE because they want their patents to be not used by patent trolls, let's say. So those kind of conditions can be brought in.
Excellent. Yeah. So yeah, I think there's certain conditions you can put on licensing like that. But like you said, with cells, you're kind of transferring pretty much all of the rights there. Another one is during the patent registration process, before the patent's actually granted, how do we protect our patent during that time?
So before the patent is actually granted, if you've already filed, then you know that date on which you are filing, you're doing the first filing, that is your protection date. So if, let's say, you filed something on January 1, 2021, and let's say on January 2, 2021, I somehow had a similar idea and I made my filing, or I started implementing it in my product. Now, if you know eventually 3 years down the line you get your patent granted, you have all the rights to sue me for for the revenue or the profits I made while your patent was in prosecution. That's one. Other thing I always recommend is that before you file it, once you filed it, even if it's not published, but that your application is now with the patent office, you can feel free to start using patent pending on all your conversation communication, marketing communication. And you can feel free to share that technology with everyone. But before that, before you filed, an NDA is the bare minimum requirement. So before disclosing anything that you've built, sign an NDA with the person that you're disclosing it to.
Right, because that's the real vulnerable point, is before you actually file.
Yeah,
you can't publicly disclose it, or else your right to file goes away. So you have to be very careful about disclosure
absolutely.
prior to filing. But once you file, you set that date in motion, and you're pretty good at that point.
Right.
Another question is, are there strategic and protected patent and technologies that nobody can sell, like military technologies?
Yes. In US, so there are three bodies, government bodies. There's there is one governed by Department of Commerce, and there is one governed by the Defense Department. Uh, so they control uh, many things related to certain technologies. Definitely, defense technologies come in that, and even some cryptography related technologies do come into that. So yeah, there are areas where you cannot transact patents.
And that's enforced by different federal governments typically?
Yes.
I see. Okay. I think we can try to do one last question and then we'll wrap it up. So someone had asked, what's the difference in submitting an industrial design as a patent and as intellectual property? I think there's maybe some clarity around design patents maybe there.
Okay. Could you say that?
They said, what is the difference in submitting industrial designs as patents and as intellectual property? Well, patents are intellectual property, so I don't totally understand the question exactly, but I think it's just the clarity of design patents, because a utility patent covers the function of something, a design patent covers the design of it, which includes the industrial design.
Yeah, I have one, I think I relate to where this question is coming from. For example, even in India, for example, we don't call it design patent, we call it a registered design or an industrial design. It's the same thing. US calls it design patent. Many other countries don't call it patent, they call it design, just design. So when you say I'm submitting my design for a design IP, that's also correct. And in US, that design IP is actually a design patent. So that's the only difference.
Yeah,
It's
there are some differences in language and other details from nation to nation, for sure.
Yes.
And I had another quick question. I guess this will be the last one. If I'm in a country that's a small country, maybe it's more developing economy, is there any value in filing a patent there, or should I just skip that and go file it in the US or Europe, for example?
It depends. In some countries, you are bound to make your first filing in the same country. Like, for example, in India, you cannot, as an Indian inventor, you may not be, you're not allowed to file a patent first in any other country. You'll have to either first file in India or take a foreign filing license before you go out. And whereas in some countries, like in Canada, many people make their first filing directly in US. and probably, after that they'll come to Canada as well, but the first filing is in US.
I
So
see.
depending on the laws of your country, you are allowed to make your first filing outside your country as well.
All right, very good. Well, those are excellent answers, and there's tremendous amount of nuance and detail to be understood in international IP laws, because every country has their own set of IP laws and how they enforce it, and even in like the U.S., that changes from one presidential administration to another. Some are more conservative, some are more liberal, and how they want to enforce patents and use patents, and so it's quite a shifting landscape from country to country and time to time. So I want to thank you very much for your time and your input. This has all been extremely insightful and helpful. And so I'm going to wrap it up. I will let everyone know that following this webinar, we will be sending out a recording of the webinar as well as Anant's presentation to everyone. So watch for that in your email, and we'll get that later. And until next time, thank everyone for your attendance, and thank you, Anant, for your participation.
You're welcome.
Thank you, Anthony.
You're welcome. Take care.